Michael Gaddy, Assistant Public Defender, on behalf of Ms. Almany.
I have before me a plea form that indicates that she is going to be pleading guilty to the charge of firearms charge of possession on restricted premises. And
welcome to another intense courtroom breakdown. Today's docket is packed with guilty pleas, firearm charges, bond decisions, and critical legal turning points. Pay close attention, because every plea here comes with serious consequences, and the judge makes it clear that the court does not play games when it comes to weapons, probation, and criminal responsibility. Let's dive into the courtroom.
90-day offense. On her successful plea to that charge, count one would be dismissed, and there is a sentence agreement. The prosecutor's delayed sentence under 771.1 to dismiss the case upon successful completion of delayed sentence terms set by the court. That court's full understanding.
That's the extent of our agreement, Judge.
May I have her sworn?
Raise your right hand. You solemnly swear affirm the testimony you're about to give will be the truth, the whole truth. Tell me God.
Yes.
State your name, please.
Amber Almany.
All right, you can put your hand down. Ma'am, it is this court's understanding that you're going to plead guilty to the charge of possession of a firearm in an unrestricted premises.
Yes.
Now, that is a misdemeanor, punishable by up to 90 days incarceration or $100 fine plus court costs. I think it also requires forfeiture of the device and mandatory forfeiture of the device or weapon. You understand that?
Yes.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo or her successor, likely. I don't know who's going to be handling the dockets, but Judge Garwood in the 15th District Court. You understand that?
Yes.
Okay. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form.
I did.
Any question about those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to
No.
plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will.
Yes.
And because you believe that you are indeed guilty. June 28, 2025. Location of 1514 East Hospital Drive, City of Ann Arbor, Washtenaw County, State of Michigan. And I believe that's part of U of M hospital premises. Did you have a weapon in your possession?
I did.
All right. And you were carrying that weapon?
It was in the vehicle. Yeah.
It was in your vehicle? And you understand that you were not, the hospital location is prohibited premises
Yes.
to do that. You understand that? All right. Ma'am, if I accept your plea, if you, between the time of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, first of all, would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No. No, Judge.
And have I complied with the court?
Yes. Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at the district court probation. Sentencing in this matter will be
February 17th at 9 a.m.
February 17th. Mr. Feaster, can you approach on a separate matter, please? February 17th, 2026 with them. For Judge Valvo.
Thank you.
Judge called the case of the People versus John Boyer. 3 cases.
With calm precision, the judge accepted a guilty plea while making it clear that firearm restrictions are serious, permanent, and not taken lightly by the court.
Sorry to wake you.
Good morning, Your Honor. Assistant Public Defender Chinazi Kyriakin-Rui on behalf of Mr. John Boyer. Mr. Boyer, state your name for the record.
John Boyer. Thank you, sir.
Your Honor, we would like to set this matter for preliminary exams.
All three of them?
Yes, Judge, all three of them.
Discovery is complete in all of these men.
To our knowledge, Your Honor.
And would the people have their witnesses available on the 3rd?
Yes.
Preliminary examination in person will be held February 3rd, 2026, 9 a.m. before Judge Perry in all of these matters.
Thank you, Judge.
Bond will continue. Thank you.
Okay. Thank you.
Court does call the case People versus Malik Al-Sidi.
Dr. Cheklowski for people.
Well, here she comes.
Good morning, Your Honor. Ronica Glenn requesting permission to practice under Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Stephanie Ken. And she's not in here. Hannah Apple?
Here.
She is. She stepped out for a second.
Oh, there she is. Could have been Miss Apple. I wouldn't have cared. Permission to practice is granted.
Thank you. Your Honor.
Your name, sir?
Malik Said.
Thank you.
Your Honor, in this case, we would like to seek an adjournment.
For what reason?
Just some mitigation information we're doing.
Do I have a green sheet?
You do. Yes, we do.
Have you already submitted the information or you've got to pull it together and then submit it to me?
I think we just got it, Judge. If we have a little extra time to look at maybe the 12th, if possible.
Probable cause conference will be adjourned February 19th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Ron.
Court does call the case of the People versus David Child.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Childs.
Your name, sir?
David Childs.
Thank you.
Your Honor, at this time, we are requesting a preliminary exam on both matters. And in addition, Mr. Childs would like for me to address his bond.
Discovery is complete.
That is my understanding.
People had their witnesses available the 3rd. Preliminary examination in person, February 3rd, 2026, 9 a.m. before me in both cases. Esteban.
Your Honor, Mr. Childs is requesting that Your Honor release him, grant him a personal recognizance bond with the same conditions that there are already, with the no contact conditions and the no return to the home. He is stating that he would be able to reside with his father. He is also self-employed. He is a floor installer. Yes, self-employed.
Yeah.
Yes. And he also has been working very hard while he's been in the jail to be able to show that he's made good use of this time. During these few weeks that he's been in, a little over a month, he's completed critical thinking for the future CBT. Bill Nye teaches science and problem solving, learn your strengths from the shining light, all-star mastermind facilitator pro, job seeking with a criminal record, anger management, criminal process, the basics. And he has also started.
I understand all of that, Ms. Gaines. I also understand what he's charged with. 2 counts of domestic violence with somebody that is knowingly pregnant at the time. Both are 3rd offense. expenses for,
She's not
Your
pregnant.
Honor, she's
Pardon?
not,
She's not pregnant. She's had
pregnant.
surgery to remove her uterus.
I'm just telling you what,
That is the correct charge, Your Honor. Your Honor, he also has a history of in 2023.
She has.
He has a domestic violence conviction and purchasing a firearm without a license conviction. Another 2003, another domestic violence. He has a history of an alcohol, at least one alcohol conviction in the past as well. That, along with the fact that this case, Your Honor, are very concerning, and especially the firearm portion of it. We're happy he's doing well. I think he'll continue to do well. It sounds like there's a lot of great programming. He could also benefit from addressing some of the issues that lead him to abuse his partners, and I didn't hear anything about that yet. So we're glad he's doing well. Work on it. I believe a couple of cases would potentially be available to start in as well if he's interested in that.
Your Honor, could I have just one? No, thank you.
I'm going to deny the request for any change in bond at this time. Certainly, after the preliminary examination, you can raise those issues, but at this time, it's more for bond reduction. Thank you. Court calls the case of the People versus Walter Peterson.
Morning, Your Honor. Raymond Cook for the People.
Good morning, Your Honor. Robert Ellman, on behalf of Mr. Peterson.
Peterson, can you state your name, please, sir?
Yes, Walter Peterson.
Thank you.
And Your Honor, I believe Mr. Peterson has multiple cases up today. I'm representing him in case ending in 02.
Gotcha.
Do you have 1843?
I do.
Ron Brown appearing on behalf of Mr. Peterson in 1843.
What are we doing? You're both requesting an adjournment?
Yes, Your Honor. I was newly appointed. I need time for discovery.
And I submitted the green paper.
Are these the only things holding him, or is there other stuff?
He does have other open pending cases. Bond on that one said it that was 10%. Unfortunately, my ex-jail is not loading, so I don't know if he has any out of.
Your Honor, that was, we were up yesterday on that assault and battery.
I remember. I'll adjourn this then to the 12th without objection. Probable cause conference. When did we set his next date before me? Do you know?
You were using the 4th.
Fourth. I think we did the 4th.
Yes.
So I can set this the 5th or the 12th. Which would you prefer?
Okay. We'll do the 5th, Your Honor.
February 5th, 2026, 9 a.m. Bond continue.
Thank you.
Thank you.
The cases of the People versus Amber Carr.
Victoria Bird here, Chief Assistant Prosecutor, again appearing on behalf of the people.
Michael Gaddy, Assistant Public Defender, appearing on 21 FB 1575, Judge.
He was right there. Mr. Quinn.
I can step in the hall.
Well.
Morning, Judge.
Morning. State your appearance.
Christopher Quinn, P69483, appearing on behalf of Mr. Carr.
What are we doing in these cases?
I would request an exam date, Judge, on all three matters. I have the discovery.
And Mr. Vieti, on yours?
I guess we'd request an exam date as well, Judge.
Discovery is complete in these matters?
My case, yes.
Pardon?
In my cases, yes, Judge.
Yes, Judge, as far as I can see.
People have their witnesses available the 3rd.
We will do our best, Your Honor.
Preliminary examination in person will be set February 3rd, 2026, 9 a.m. before Judge Perry.
Thank you, Judge.
Bond will continue in each case. Thank you. Court calls the case of the People versus Corliss Higgs.
Alex Jablowski for people.
Your name, sir?
Corliss Hicks.
All right, I have before me a plea form. Is that what we're doing today?
Yes, Your Honor.
Plea form indicates the defendant will be pleading to count 2 attempted possession of a loaded firearm in a motor vehicle to 1 year offense. Upon a successful plea to that charge, count 1 would be dismissed. There is an agreement between the prosecutor and defendant that the prosecutor will recommend heightened sentencing. That's the court's full understanding of the agreement.
Yes.
Yes, sir. Is that correct, Mr.
Yes, Your Honor.
All right. May I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name, please.
Corliss. All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted possession of a loaded firearm in a motor vehicle.
Yes, sir.
That is a misdemeanor punishable by up to 1 year incarceration, fine of up to $1,250 plus mandatory forfeiture of the weapon or device. You understand that?
Yes, sir.
All right. You understand also, sir, that while you're pleading guilty before me, I would not be your sentencing judge and you would be sentenced in the 15th District Court. Indicates by Judge Valvo, but she's retired, so I'm presuming her assessor or another 15th District Court judge. You understand that?
Yes, sir.
All right. Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will
Yes, sir.
and because you believe that you're indeed guilty of this offense?
Yes, sir.
On the date of December 23rd, 2024, at the location of 919 South University Avenue, City of Ann Arbor, Washtenaw County, State of Michigan, were you in a motor vehicle?
In a motor vehicle?
Yes.
No, sir.
You were at that location and you went home,
Yes,
correct?
sir.
And then when you went back to meet with the police, you had with you a bag.
Yes, sir.
And in that bag, there was a gun. Is that correct?
Yes, sir.
Okay, so certainly to the higher church. And you did not have authority to carry that weapon in that fashion?
No, sir.
All right. I think I can. All right, sir, if I accept your plea, you need to understand that if you commit misconduct as defined under the Michigan court rule between the time of my acceptance of your plea and the time of sentencing, that the court would not be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No.
No, Your Honor.
And has the court complied with the court?
Yes.
Yes, Your Honor.
Court will accept the defendant's plea guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be February 17th, 2026, 9 a.m. We have before Judge Valvo, but you'll have to figure out who that's before. Bond will continue.
Thank you, Your Honor.
Thank you.
Court calls the case of the People versus Man Davis.
Morning, Your Honor. Raymond Cook to the people.
Assistant Public Defender Davy Lipa. Well, good morning, Your Honor. Former Mr. Davis. Mr. Davis, can you tell the court your name, sir?
Man Davis. You know, all right. Yeah, I know who he is. All right. What are we doing on this?
And Your Honor, we do have an agreement today
No,
to.
I want to have some there.
Okay, now you do. Okay. We'll be setting for preliminary examination, Your Honor.
Discovery is complete.
It is, Your Honor.
People have their witnesses available the 3rd.
We'll do our best, Your Honor.
Preliminary examination in person, February 3rd, 2026, 9 a.m. before me.
Thank you, Your Honor.
Bond will continue. Court does call the case of People versus Wesley Brand.
Good morning, Your Honor.
Public defender representing Mr. Brand.
Your name, sir?
Wesley Rand.
Thank you. You're requesting an adjournment?
Your Honor, at this time, I am not requesting an adjournment. I was able to get information from Ms. Tana that the media discovery, the surveillance video does not exist. Is that right, Ms. Tana?
That's my understanding, and speaking to defendant, and that's been that information mentioned previously. So that is our understanding. There is no surveillance.
Got it.
But with that,
So that was his understanding of the plea agreement. And we were the one that made the legal responsibility.
That's just background noise. Go ahead.
okay. So with that, we would be requesting the preliminary examination in both matters.
So your discovery is complete now.
That is my understanding.
You have other witnesses available the third? Preliminary examination in these matters will be set in person February 3rd, 2026, 9 a.m. before Judge Perry. She had that other one. Did we balance this out? All right. Bond will continue. Thank you.
Thank you.
Court calls the case of the People versus.
Alex Chavalosky, the People.
Assistant Public Defender Jay Bellinger on behalf of Ms. Ernest, who appears in person, not at the hospital, Your Honor.
With calm precision, the judge accepted a guilty plea while making it clear that firearm restrictions are serious, permanent, and not taken lightly by the court.
Can you please state your name for the record?
Adrian Ernest.
Thank you.
And Your Honor, we are just seeking to set this matter for preliminary examination. To our knowledge, discovery is complete.
You have other witnesses available the third?
Yes.
Preliminary examination in person, February 3rd, 2026, 9 a.m. That is before me.
Okay. Got it.
Bond will continue. Thank you.
It's not going.
So,
Court calls the cases of the People versus Bobby Black.
Public Defender Hannah Apple appearing on behalf of Mr. Black, who's approaching now.
This courtroom session shows how fast justice moves when firearms, bond requests, and criminal histories are on the line. Guilty pleas were entered, bonds were denied, and judges made it clear that second chances come with strict rules. If you want more real courtroom breakdowns and legal drama explained, hit like, subscribe, and tell me, do you think these offenders will stay out of trouble or end up back before the judge?